all for attending today's webinar. This is the first in a series of 4 presented by my partner, Bryan Meek, talking about various hot topics related to employment law. We're going to kick it off today talking about the future of non-competes, their enforcement, and various ways that employers can protect themselves, especially if we see some changes in the enforcement of non-competes. Bryan is a partner here at Brennan, Mann & Diamond. He is co-chair of the Employment and Labor Law Group. We are so grateful that he's going to be sharing his knowledge with us today. If you have any questions, I'll be monitoring the Q&A box, so please feel free to type that into the questions box, and we'll try to get all of your questions answered in the next 30 minutes. So welcome, Bryan. Thanks for being here today and sharing this knowledge with us. I'll turn the floor over to you. Great. Thank you. And as you all know now, my partner and member attorney at Brennan, Mann & Diamond is with me today as well, Amanda Waesch. She's a fabulous attorney in our healthcare division, and I thought it'd be great to kind of have that healthcare aspect as well. That's going to really intersect with the employment non-compete issues we're going to discuss. Obviously, this topic has really come about as a result of many of you here today, and then many of our other clients who had questions regarding the potential limitations or outright elimination of non-competes nationwide through the Federal Trade Commission's proposed rule. So we're going to discuss that here today. We're going to discuss, what our clients are maybe doing to prepare for that potential elimination, and when we might expect to see those changes come about. So before we get started, I'm just going to go through the slides here. Let's just briefly recap what a non-compete agreement is. So I'm sure many of you on the phone know, but in case you don't, a non-compete agreement is essentially it could be a provision of a contract or a standalone agreement that limits or prevents a employee, either a current employee or a former employee, from working with a competing company when they either work for you or they leave your employment. And usually those are limited to a certain radius, 10, 20, 30 miles from where that employee worked, and for a certain period of time, typically 1 to 2 years. We're going to discuss some limitations there in here in a moment. But these are enforceable agreements that employers really use to help protect their trade secrets and confidential information, as well as their marketplace position, and ensuring that hey, employees aren't going to leave, especially those who really have this intimate confidential knowledge, going to a competing employer, sharing that knowledge, thus cutting into your market share. Amanda, do you use a lot of non-competes in your healthcare? I do. I highly recommend them in my documents, both employment agreements, and then also if I'm representing a company, I strongly recommend them for the owners, so that the owners are not able to go out and directly compete, at least within a certain geographic radius, for a certain period of time. Sure. So, and I know, I think Amanda hit on a couple of these there, but when we speak with our clients and we say, hey, why do you want to use a non-compete? We always have that conversation with them first before we draft one for them. These are the primary reasons that we're given, these 1 through 4 on the screen here. Number 1, protecting that disclosure of trade secret and other confidential information. So especially these high-level employees, when they work for you, they gain access and knowledge to this information. We don't want them stealing or remembering it and going to their future employer and sharing all that information with them that our clients have spent years and countless dollars accumulating. The second being, again, as I had mentioned, maintaining that competitive advantage in your marketplace. So protection of employees. If you have some super skilled employees that you've retained and spent that money to train them, onboard them, recruit them, you want to ensure that they're going to stay with you and they're not just going to enter your marketplace, jump ship, go to work for a competing employer. I think that's really big in healthcare as well. Situations where if you've brought on a specialized physician who really has this expertise that no one else in your community has, you want to ensure that, hey, you're keeping that person with you, and they're not just going to
kind of get started in, your community, say Akron, Ohio, and then just go down the street to a competing hospital or something along those lines. The third being to reduce employee turnover. If employees know that, hey, they have this non-compete and they're not going to be able just to, jump ship, go to an employer down the road, they're actually going to probably have to uproot and potentially move to a neighboring community or neighboring city. They're less likely to engage in, efforts to, maybe leave your employment. So non-competes do have that potential of reducing that turnover, and really even just the threat of a potential enforcement of a non-compete hanging over their head can have that effect, even if employers don't always go through the steps to actually enforce them. And then finally, as Amanda had mentioned, preventing competition from the sale of a business. So if a person is selling their business, you want to put a non-compete on that person as part of that sale to prevent them from just going down the road and reopening that same business, taking that goodwill that you spent all that time and money acquiring with them. So their customers are just going to shift over to their new business. So it's very imperative in the sale of a business as well. So let's talk quickly about the enforcement requirements of a non-compete. Prior to these proposed rules from the FTC, non-competes were really governed at the state level. So either through state law or through state common law precedent that's established in the courts. So every state varies. But so, for example, here in Ohio, our non-competes are primarily regulated by common law precedent. We have to look at court decisions for precedent as to what extent we can enforce a non-compete. But generally, in order to enforce a non-compete, you're looking at 4 prongs here. The employer having an interest that they're trying to protect, geographic limitation, and a temporal restriction, and then 4, kind of having that cognizable harm when you go to that enforcement stage. So I want to go through here for a moment a couple of these, but the first being the employer's interest. You need to have something that you're actually trying to protect. I remember a couple of years ago, there was a famous nationwide sandwich company that put non-competes over their sub makers that worked, just with the customers on the front line making the subs for them. And they try to put all those employees under non-competes, saying that, hey, the way they construct a sub is, confidential and trade secret. They need to protect that. And in this case, the courts looked at it and said, no, the consumer standing on the other side of that glass can see how that sub is constructed. It's no secret how sandwiches are made in America, and you don't have anything special you're trying to protect. A second quick example, one coming from healthcare. I previously had a case where a hospital was trying to enforce a non-compete against one of our anesthesiology clients, saying, hey, our client was leaving that hospital, going to one that was within the geographic distance to another hospital. And the former employer said, hey, they can't go there. We're enforcing this non-compete. We successfully argued to the court, well, hey, he's an anesthesiologist from a hospital going to another hospital. As people in healthcare know, no one chooses their hospital where they're going to have a surgery at. They're not choosing the anesthesiologist that's going to treat them at that hospital. So there's really no business interest you're really trying to protect. When it comes to geographic limitations, again, that's really governed by state law or state common law precedent. In Ohio, we routinely draft non-competes that are 25 to 30 mile radius, but really it's an individualized analysis for each client to determine how far out you actually need to protect. If, for example, you're a business and you encompass the entire city of Nashville, there's no other competitor in Nashville, you're probably going to be able to have that limitation encompass that entire city, but you might not be able to get one over in Knoxville when none of your clients or customers are coming from Knoxville. Temporal restrictions. In Ohio, just as an example, we routinely draft non-competes that are 1 year to 2 years in length. Some other states, such as Florida, have additional restrictions that can range. I think if physicians, even in Florida, are limited to about 1 year. But again, it can be industry specific. But then we also, again, have to look at what interests and for what period of time is the employer going to try to protect? Again, most states do not go above 2 years without showing some sort of extra need that can clearly be established. And then 4, you just got to be able to show some harm if you're going to try to enforce those, be able to articulate to a court where that harm is going to occur. Can that harm come from them stealing patients or clients? Again, in the example I gave of the anesthesiologist, they're not stealing any patients or clients. That hospital is not going to experience any harm. So just one of those factors that we analyze before enforcement. Amanda, I guess in the healthcare space as well, have you ever negotiated, for negotiated a non-compete buyout, instead foregoing the enforcement of it?
I have. I typically don't recommend that. In some states like Texas, then for a physician, the non-compete has to include an option to buy that out. It can be really hard to value, what is the value of that economic harm by that physician competing. And once you establish the precedent of, I'm going to allow this employee to buy out their non-compete, you establish a precedent going forward. So Sure. It really is a strategic business decision that the employer needs to make, especially to protect the enforceability of the non-compete. But I do encourage a buyout over, considering a buyout over potential litigation, especially if the client is really litigation adverse, and Sure. it's going to be a fight, and a very expensive fight.
Sure.
So it's a case by case basis, in determining whether we fight it, enforce it, whether we buy it out. So it's really going to be a facts and circumstances test.
Sure. So with all this information in hand, let's talk about what the Federal Trade Commission is now proposing. So they have officially filed a proposed rule that occurred in January of 2023 that essentially states that they're going to place a nationwide ban on the use of non-compete agreements for all employers. That's the proposed rule is very broad. It's fairly short for a federal regulation as well, but essentially they're saying, hey, this is going to be our proposed rule going forward. Now we're going to open it up to questions and comments from the communities. And, some of our clients and some of you on here today may have actually submitted public comments to that proposed rule, having an issue with it or having questions for it. And then once they review those, they'll issue their final rule that we're going to get to in a moment. But what is the rationale behind the FTC's decision to issue this nationwide ban? As I said, non-compete's usually regulated at the state level. So why is the federal government now coming in and saying, hey, let's put a ban on these? Well, first, it's been no real secret that the Biden administration partially campaigned on an elimination of non-competes, but has generally disfavored non-competes. So how does the FTC's jurisdiction come in? Well, the FTC is now arguing that non-competes essentially serve as a limitation on competition, which they argue falls under the federal jurisdiction purview of the FTC, trying to ensure that there's open competition in marketplaces. So they're saying that non-compete agreements essentially block workers from freely switching jobs, again, because it's required them to move, uproot their lives, etc. Deprive workers of higher wages and better working conditions. Essentially, if workers don't have the ability to freely move between employers, there's a lack of incentive for employers to increase benefits or wages to ensure marketplace competition for employees. And then obviously depriving businesses of a talent pool. So on the flip side of this, as a benefit to employers, let's say there is some specialized computer engineer at your competitor down the street. Well, you might be willing to pay that engineer an extra $50,000, $100,000 a year to come work for you because there's a specific need that they're going to fit into. With non-competes, it's not going to be able to happen. Take those away. You're now going to be able to recruit within your community for talent. So there are really, 3 key things that this ban is going to put into place. It's going to establish that, number one, there's an unfair method of competition for an employer to enter into a non-compete clause with a worker. Number 2, it's going to it prohibits you from maintaining a worker who has a non-compete clause. Basically, you have to eliminate that if they're going to continue to work for you. And number 3, basically, it's stating that the ban is going to establish that any worker basically that, you can't have these de facto type non-competes in place. So we can't make non-solicitation agreements, confidentiality agreements so broad as to essentially serve as non-competes. So those are really the specifics of the proposed ban that will be in place. And we're going to get into some more detail here in the coming slides. But it's important to reiterate that this proposed ban will also serve as an elimination of all existing non-competes that you have in place. So, for example, if all your employees are currently subject to non-competes, if this final rule goes into effect, those are all going to be eliminated day one, again, if they go into effect. So there's not going to be a grandfather clause that we see in some other states like Colorado used when they implemented their restrictions on non-competes. I guess another important component here, since we've touched on it a couple times today, is for sales of business. Under this proposed rule, you're not going to be able to impose a non-compete on an owner who's selling their business unless that owner had at least a 25% interest in the entity being sold. So a further restriction on the use of non-competes for sales of business. Again, as I just said, the proposed ban would require rescission of all non-compete agreements entered into their compliance state. And Amanda, I think we had briefly just touched base, as preparing for this this webinar, what effect could this rescission have on existing agreements to the extent that they don't have certain clauses that allow for, voiding of certain terms under the precedent of illegality?
Yeah, Bryan, I think this is going to have wide sweeping effect if employers are not prepared for it. There are some very well-written employment contracts out there that are very broad. And so they do cover the non-solicitation, the no hire, the confidentiality, the trade secret, and the non-compete. So if it's very well written, there could be some protections for the employer that are still in place from a contractual perspective. But we know that there are some employment agreements out there that are not very well written. And we look at those and we say, well, this non-compete's not really well written. We question its enforceability. If there are no other protections in there, like non-solicitation, confidentiality, trade secret, that employer is going to be left with very little to no protection. The other thing that we need to look at from a state law perspective is the effect on the contract. So if the confidentiality provision is deemed to be non-enforceable because this regulation goes into effect, that could nullify the entire contract. So we need to make sure that we're looking at our miscellaneous provisions in the contract, that there's a savings clause in there. And you're going to find this again usually at the end of the contract, a savings clause that says if any provision in this agreement is deemed to be illegal, unenforceable, invalid, it does not invalidate or nullify the enforceability of the entire contract, all of the other contractual provisions. So no matter how you feel about non-competes, you do need to go back and check your agreements and make sure that you have that savings clause in there in case there is a change in law that's going to impact the enforceability of the contract as a whole.
Absolutely.
So this is a good time to check up on your contracts and just make sure that you're checking all the boxes for all the provisions that you need to have in place.
And especially to have ensuring those updates are made as well as, like you said, moving forward. So if you don't right now, now's a good time to get those form contracts updated. So as I had mentioned, the proposed rule would also ban non-compete lookalikes, de facto non-competes, if you will. Some examples of those would be a non-disclosure agreement that is essentially so broad that it would effectively preclude the worker from working in the same field that their employment, once their employment ends. So if for, some reason you said, to a Subway worker, for example, hey, we've taught you how to make a sandwich and that we're putting a non-disclosure on you that says you could never use the technique of making a sandwich ever again because it's proprietary to us, then essentially that non-disclosure is having the effect of a non-compete, because now that Subway worker can't go over to Jimmy John's or Jersey Mike's and use the knowledge of making a sandwich to then work for them. So that'd be an example of a de facto non-compete. Another type would be, an agreement between an employer and a worker that requires the worker to pay for training costs or onboarding costs if those costs are not reasonably related to the actual cost the employer had to spend to do that training and onboarding. So, for example, if you had a contract that says, you can't work for, or let me just say this, if you have a contract that says once you leave, if you don't give us a certain amount of notice, you have to give us $100,000 as a penalty. Well, if that $100,000 penalty isn't rooted in some sort of rational basis, tying it to that onboarding, training, credentialing and healthcare, something like that, then that's going to serve as essentially a ban on them going down the street and doing the same job or doing another job for a competitor.
Bryan, I'm
Yeah,
a huge fan of early termination penalties, or at
absolutely.
least clients considering them, especially in healthcare, because when you onboard a physician or an APP, you have the credentialing costs. You may have increased staff, right? You may have to hire an MA for them or have increased staff. There is some additional training costs. There's a lot of sunken costs, and it takes a long time to recoup those costs until that practitioner is profitable. So I think it is easier to tie some of these early termination penalties to a cost, but the employer needs to make sure that they do that. And I'm also a fan over time that cost decreases, because that employee is becoming profitable and is paying off some of those costs. So that may make it more defendable. But it also helps with that employee turnover that we talked about. So I do encourage employers to consider early termination penalties.
Yeah, absolutely. I agree with you there. And that is one of the ways that, employers are going to combat a world where, non-competes are potentially eliminated. And that's one of the main techniques. And as long as it's rooted in some sort of rational basis for that calculation of that buyout, then, that's still going to be able to be enforced. So as we look, just real quickly here, we're not 100% sure what the FTC's final rule will look like. I suspect they're going to claw back a little bit from this nationwide ban. But again, we're just not sure what the final rule is going to look like yet. But just looking at a couple other states, for example, you kind of run the gambit of restrictions. So in California, as most of us know, non-competes are almost entirely unenforceable in the state of California. But you look to states like Colorado, they've kind of taken a middle of the road approach, which is to say, and maybe this is someplace the FTC may go with their final rule, which is to say, hey, certain employees can be bound by a non-compete. In Colorado, that employee has to earn at least $100,000 to be bound by a non-compete. You can also use non-competes in the sale of a business, so to protect that goodwill that you're purchasing. You can also use them for extreme trade secret protection if you can establish, the need for that extra trade secret protection beyond what trade secret laws already provide you. You can also use, non-competes in Colorado to the extent of limiting where they can work until they pay off some sort of scholarship or training costs, something along the lines of what we just discussed with Amanda. So let's look now, and we have a couple moments before we open it up to questions, but let's take a look at what some employers are using now to prepare for a world where potentially non-competes no longer exist. And the first being, they're really strengthening up their confidentiality agreements, making sure that those confidentiality agreements are as broad as they can be within the bounds of the law, without being a de facto non-compete, but especially ensuring that patient or client data is protected, ensuring that methods and processes that were actually developed by the employer and not industry-wide known are protected. That way, those employees, if they do leave, because now they're going to be able to, they can't take those patient client lists with them. They can't take those processes with them. They can't take those documentations with them. The second thing that employers are really using, and it's one that's been around for a while and usually tied to a non-compete, but they're really strengthening up the non-solicitation provisions. In the vast majority of employment cases I see, especially when you're dealing with non-C-suite employees, the use of non-solicitations is going to still protect your business interest over a non-compete. So using non-solicitations to ensure that the departing employee can't take patients, clients, customers with them. They can't take employees with them. So sure, you can go to the competitor down the street, but it's just you that's going, and you're not taking our patients, our clients, our employees, and you're not taking that confidentiality information either that we just put and protected under that clause. So really strengthening those provisions up is what a lot of our clients are now doing, coming to us and saying, hey, can you retake a look at our non-solicitation, relook at our confidentiality provisions, make sure these are as enforceable and broad as they can be. And then another one is one that we kind of spoke with, Amanda just spoke on, is contract duration. So ensuring that your employment contracts are set for a certain duration of time. So maybe the employee needs to give 6 months notice if they're going to leave, right? That gives you time to really replace them, get someone new, get someone trained. But that 6-month notice really also keeps them from jumping ship as easily, right? Because sure, they can go to a competitor down the street, but they got to interview and be hired by them. And then they got to sit with you for another 6 months, right? Or, they got to put in that 6-month notice before they can even start looking for a job. That is going to be a psychological hindrance to leaving. And then if they don't provide that notice, as Amanda said, definitely having that provision in place that would require them to have to pay for the rational, logical, explainable damages that would be incurred as a result of their early departure, such as those tied to training, onboarding, credentialing, etc.
And Bryan, there can also be forfeiture of payments too, right? So instead of the employee paying the economic penalties, the early termination penalties, or penalties for not following the contract terms, there can also be forfeiture. So forfeiture of any like sign-on bonus or repayment of sign-on bonus, forfeiture of any productivity bonus, the requirement that they cover their tail, or even pay a portion of their premium, their professional liability premium. So there can be some forfeiture and some additional financial penalties for not following the contract provisions.
Absolutely. Absolutely. So in the last couple of moments we have here now, let's talk about where things stand with the FTC proposed rule. The public comment period, as we had mentioned, a lot of our clients submitted public comments, but that period ended on April 19th, 2023. So essentially, the FTC received over 27,000 comments, basically saying, hey, we agree with this, or no, we don't agree with this, or hey, have you thought about this yet? Or maybe you should put this type of provision in place, just to ensure that the FTC has all the industry-wide knowledge that they can gather before they issue their final rule. So as a result of the amount of comments that have been received, the issuance of the final rule has been delayed a little bit. They're now looking at April 2024 before a final rule is going to be issued. And we're looking even from that probably 60 days to 90 days before enforcement actually takes effect. So we're looking at probably not until the summer of 2024 before we have clarity on this issue. And obviously we'll continue to keep you all updated as we know more what the final rule will look like. We oftentimes get rumors and kind of feelings of what things might look like prior to them being announced. So we'll obviously let you all know and keep you all updated as we know more in that regard as well. But just in the interim, be reviewing your non-competes, be reviewing your non-solicitations, confidentiality, trade secret protections, ensuring those are beefed up, especially with your new employees that you're onboarding now. It's very likely that many of those employees are still going to be employed next summer. So we need to prepare, as Amanda said, to have that savings clause in your contract as well to future-proof those contracts if and when the potential comes for this nationwide ban to take effect.
Thanks so much, Bryan. If any of you have a question, please feel free to type it in the question box. We do have a couple of questions. So as you guys are typing in your questions, just a couple of housekeeping things. All attendees and all registrants are going to receive a copy of the slides and also a copy of the recording from today. So be on the lookout for that. That should be in your inbox in the next day or two. So Bryan, we have a couple of questions regarding patient care, especially if we're dealing with employees in the healthcare sector. How do we deal with the physician or the provider-patient relationship and ensuring continuity of care? Do you have any comments on that?
I have a few that I employ in my practice, and you may as well, Amanda, have some others, but ensuring that continuity care is, and one of the things our clients use is those very lengthy notice periods. such as, 6 months, where that physician needs to give 6-month notice before they leave. And that ensures that you have time to really transition those patients and have a planned transition for those patients to your existing providers that will remain with you, and ensuring that continuity care and that changeover from one physician to the next, and then building into those agreements requirements that once they do give that notice, that they then have to engage in that transition process. And, it's not something they can just skip over or they can ignore. They actually do need to engage in that process.
Yep.
Is there
Good advice? Yeah, I always make sure that I address ownership of medical records. It's going to be a state by state requirement. Typically, they're going to be corporate records. So making sure that the employer is the owner of those records, and outlining how the employee can have access to those, or the patient can have access to those. So making sure that those guidelines are outlined in the contract. Again, making sure that we're consistent with state law and with HIPAA. And then I also include a provision where the notice that is sent to patients is either going to come from the employer, or it's going to be a joint statement from the employer and the provider. Again, that's going to largely depend upon state law and the state licensure rules that are going to be governing that physician-patient relationship. But we want to make sure that we comply with state law, but then also that the employer, to the extent possible, controls the narrative. So that will help with patient attrition, and then also help with disparagement and things like that. And that will help with the continuity of care, and any patient abandonment issues, or any questions regarding access to medical records. All of that should be outlined in that patient notification. And again, that needs to be in your contract, because if not, typically that's what we fight over when an employee is leaving is, how are patients notified? When are they notified? Who's sending it out? And that can cause a bigger fight. And then we lose track of, patient care and continuity of care.
Yep.
Okay, our next question, Bryan, is can you just recap for us when the final rule is anticipated?
Sure. So I put that back up on the screen now. So as of right now, the earliest we expect the final rule to be issued, and this came out just a couple of weeks ago from the FTC, is that we're not looking until April of 2024 before the final rule is published, and essentially the public would have access to it. It won't take effect for at least another 60 to 90 days thereafter. So we're really looking at the summer of 2024 before anything can really be enforced under these limitations.
Thanks, Bryan. Another question, this is a good one. Are there any professions or any categories of employees that are already banned from having non-competes? For example, attorneys, those tricky attorneys, we carved ourselves out. We're not allowed to put non-competes on our employees, our attorney employees. But are there any other professions or categories of employees that are already banned, Bryan?
That is a great question. And I always, that's such a funny aspect that lawyers until very recently were the only regulated profession that was not allowed to have non-competes. And again, it's because we write the rules, I guess, or our profession writes the rules. But the one that's really taken steam recently, and we started to see this with limitations in states such as Florida, and then now Colorado, where they have bans, particularly for physicians. And in, for example, Colorado, physicians are not allowed to have an enforced non-compete, but you can include a non-compete in a physician contract, but you only can sue for damages as a result of their competition. You can't enforce them not going to a competitor. So it's, basically you can still sue them for the damages of violating the non-compete, but you can't actually get an injunction and have the physician not work at their new employer. But I'd say the only other one that I'm really aware of that's a nationwide, that there's more scrutiny on is physicians. But again, it is a state specific thing. So in Ohio, we're still free to put non-competes on physicians, and many of our clients do. So that's one of those things that you'd want to get with us on to figure out what limitations may be on those physicians in your state.
Great, thank you. So our last question is about solicitation. So if you could just take a couple minutes to talk about solicitation. Sometimes I think there's a lot of confusion as to what is solicitation and what can be deemed solicitation. So our our audience member asked a question: what if a provider starts advertising on a social media, or sometimes it can be billboards or mailings, 2 weeks or 2 months prior to leaving, and trying to get, patients to join them at their new practice? Is that direct solicitation, indirect solicitation? Is that solicitation at all? Can you address how
Sure.
advertising intersects with solicitation clauses?
Sure. So to start, I'll say broadly, it's really going to depend where the limitation is going to depend on what the contract language is. Solicitations, much like non-competes, are contract provisions. So we can make the limitation really be whatever we want it to be when we work with you and figure out what your goals are. So in the example that was provided, providing a general advertisement to the community would be indirect solicitation. So does the contract provide that indirect solicitation is not permitted? If not, that might be something we want to work with you to amend. Most solicitations provide for direct advertisement or direct communication rather than indirect, but again, it can be tailored to your needs. So direct would be, picking up the phone and calling that patient or that client or that customer and saying, hey, I'm leaving and I'm coming over there and you should come work with me as well. Those indirect, again, are like the billboards. Now, when it comes to solicitation while they're still your employee, again, that's something that would be built into the contract to say, hey, you can't take any efforts to solicit until, within the bounds of this agreement until after your employment with us ends. That way you just ensure that, that overlap period doesn't really occur. But again, we can really work with you to tailor your non-solicitation to be as specific and broad and protective as you want it to be.
Mm-hmm. And just to piggyback on that, Bryan, so again, it depends on whether you're in the employment term or whether it's after the employment term, or it could be, if you're in the termination period, that's still the employment term. What does the agreement say? But we had a case where an employee was soliciting and they were picking specific zip codes that were serviced by that practice. And so that could be seen as indirect solicitation, because even though they weren't directly soliciting specific patients or the patient list, they were selective in their selection of zip codes or their geographic target area. So again, we need to pay close attention to what the agreement says, what are the terms of the non-solicitation, and then also what is the conduct that we're discussing, the facts and the circumstances around that.
Absolutely. And I think real quick before we move on, I do want to emphasize one key component of this proposed rule as well. And that is going to be that you can still have a non-compete on your employees while they work for you. So that overlap period, we can restrict, and you can have a non-compete for these employees during their employment with you, including their termination notice period. So that is an important caveat. It is a nationwide ban on non-competes for post-employment periods. I just want to make sure that that's clarified. During employment, we can still restrict, where they work. And I think most employment agreements have that. Any sort of other work opportunities that may be available to that employee have to be approved. But again, we can still have those restrictions in place during employment.
Yeah, great distinction, Bryan. So that's another provision that we want to look at in our employment contracts. What type of outside activities are you going to allow your employees to engage in? And then, of course, if there's any sort of professional activity that may require professional liability insurance, we need to make sure that that's in place as well to protect that employer. So great. Well, thank you all for some great questions. Thank you all for joining us here today. If you have any additional questions or anything specific to your situation, please feel free to reach out to Bryan or I. Again, everyone will receive a copy of the presentation and the replay. So be on the lookout for that in your inbox. And then please mark your calendar to join us for the next free webinar, which is going to happen on October 25th. Bryan's going to be talking to us about employee misclassification and also discrimination in the workplace. So 2 very timely updates there. So mark your calendar and be sure to register for that webinar. So thank you all for joining us today. Bryan, thanks for sharing your knowledge with us. We'll look forward to your updates as we approach the finalization of the rule.